if jobs, positions are in the same job class, you have to know whether they involve similar duties and responsibilities. Do they have similar recruiting procedures? Do they have similar qualifications? Do they have similar rates of pay or compensation or salary scales? All of those are facts that you need to know before you can make any decision about whether a position or a group of positions should be considered as the same job class or a group of jobs. And therefore, it is absolutely essential, if you are acting on behalf of union and employees, to get that information, because otherwise you will never be able to make an intelligent decision about the job class. So the first thing is to have full information. That will also be necessary because you may well be dealing with a compensation scheme or a job evaluation plan where you have job titles that are not necessarily reflective of job content. And you may well, for example, with a large employer, you may well have hundreds of employees classified as clerk 1, clerk 2, clerk 3, clerk 4, and they could be doing an incredibly broad range of functions which may or may not be similar, which may or may not require similar classifications, which may or may not, or similar qualifications, which may or may not have similar recruiting procedures. And the only way you will ever know that and be able to make an intelligent and informed decision about the appropriate job class is to get all that information and break it down and apply it to the situation that you have before you. And I'm not, obviously there, when you're not getting that information, you do have the option to explore these facts with a hearing officer or subsequently with a tribunal, as was done in the cybernetics decision, but I don't think that's really what I'm here to talk about. Now, what are the other kinds of problems? Well, first of all, there's the broadbanding problem that I alluded to. And it becomes important for this reason. You have your female job class, and you're looking around for male comparators. As the Act requires, you have to look within your bargaining unit first. And there may be a number of persuasive reasons from the union's point of view that you want to look within your bargaining unit first. And again, this varies from situation to situation. But for example, you may be extremely happy with the internal relationship between the female job classes for compensation purposes within your bargaining unit. And really, your only problem is you have a couple of anomalies over here in the male-dominated job classes. I think Irene Harris has handed out the Equal Times, the QP Pay Equity newsletter. There's a really good example in newsletter number 2, which is one of the ones you didn't get, unfortunately, about a QP unit that had a whole bunch of I think what we would think of as classically clerical duties, the clerk, typist, receptionist, stenographer, and various levels of receptionist and clerk. And then over here, all of those were female-dominated. Over here, you had an audio-visual technician, male-dominated class, the only one in the whole group. Now, in that particular instance, the unit was very happy with the internal relationships between the female-dominated job groups. They were unhappy because they felt that the male-dominated classification, that is the audio-visual technician, was an anomaly, got paid a lot more. In that kind of a situation, you may well want to be maintaining that internal relationship with the female-dominated job classification. Okay, now there may be some situations, though, where those male comparators look at first blush to be inaccessible because they are grouped on this, using this banding concept, with some groups that have been traditionally female-dominated, and because there are more of these female-dominated positions than male-dominated positions, they may be grouped with a whole lot of female-dominated positions. Now, I think the classic example of this would be in the hospital sector, where you have a lot of, you have the director of nursing who historically would probably be a female, a number of other positions, and then you may have a couple of male-dominated classifications that would be finance and office positions. Now, you may have a female job classification you want to compare to that male job classification, but at first blush you can't because they seem to be categorized with the female groups that you can't compare with, obviously. The question is, can you separate out that male group? And this is, again, when you go back to first principles in terms of what are the duties, what are the responsibilities, what are the qualifications, and there are many, many occasions when you may find, when you have all your information, that you can legitimately, relying on the definition of job class in the Act, separate out groups that had previously been lumped together, and that may well be to your advantage. You will, by doing that, achieve the most for your members and achieve, of course, the objectives of the Act. So the first piece of advice I had for you is don't accept a job evaluation scheme that is there. Don't accept banding. You have to look behind that, unpack what's there, and as I say, reconfigure. Then you have the reverse example, and that is the situation where you have a large number of similar classifications. And again, I'm going to use the hospital example, and this is the group of technologists. And for both of these examples, I'd like to thank Isla Peters and Francis Lankin of OPSA, who spent a long time talking to me about job class. In any hospital, there are usually a large number of registered technologists, and quite frequently this is a female-dominated class, a female job class. But there may be certain types of registered technologists who tend to be male, and I think this sometimes happens in the biochemical labs. So when you consider all of the registered technologists as a group, it looks like a female job class. If you split them up and consider them by subcategory, you may end up with some male job classes within that group. Now that, in fact, and it I think has been the union's experience, at least in some hospitals, that it is counterproductive from the union's point of view to separate out, to have these multiple little, 1 or 2 unit male job classifications, and it is in fact much more beneficial and perhaps closer to the spirit of the Act to have all those groups considered as one job class or as a series, a group of jobs, which is something we'll deal with in a minute. Well, in that situation, obviously, it is to your advantage, again, to go back to the definition in the Act and say, look, these are in fact the same. So there's no sort of general truth as to what it is appropriate for a union to do, or for that matter, for an employer to do. And every situation has to be considered on its own facts, keeping all of these various permutations and combinations in mind. The next concept that's very important from my perspective is the group of jobs concept, because often that will help you deal with some of these problems. You may have jobs, again, I'll go back to the clerk 1, clerk 2, clerk 3, clerk 4 example, which are in fact substantially similar, and there's no question that they are similar jobs, they're the same job class. You may, on the other hand, have them where they have clerk 1, clerk 2, clerk 3, clerk 4, where there is a clearly defined progression, and the qualifications for one may be quite different for the qualifications for the other, but if you worked your way through the various levels, you'd ultimately end up at the clerk 4 position. In that situation, if you are in that situation, you may well want to explore the group of jobs option in Section 6 of the Act. And again, I'll go back to that QP example that I gave before. In that case, you had a lot of what you could describe as disparate positions: clerk, typist, receptionist, accounting clerk, confidential secretary, library film technician. And the only male comparator apparently within the unit is the audiovisual technician. If you take the position that each of those female job classes, or each of those positions is a separate position, you may run out of male comparators within the unit, and for various reasons you may want to stay within the unit. What the group of jobs concept allows you to do is to group a number of jobs together, and then you only need one male comparator. The job rate for the class, because there may be obviously a variation, would be the job rate of the most heavily populated position within the class. What it allows you to do, as I say, is to not have to hunt for 50 different male comparators. You can use one as a benchmark comparator in a sense, and then when you use your benchmark job rate, you make your comparison, and then everybody within the unit would get the same dollar increase. I think that's Section 9, Subsection 3. So from a union point of view, the group of jobs concept can be extremely useful and can, as I say, prevent a hunt for male comparators, which, if you divided it up class by class instead of using a group, could prove fruitless and extremely frustrating. And that really brings me to my last point, which is, I think when we started out on this course, we didn't really know exactly how it would pan out or exactly how to negotiate these things, because there are so many different factors at play, including the existing collective agreement and your current negotiations on an ongoing basis, perhaps under the Labor Relations Act. And I think that what a number of people did was negotiate their gender-neutral job evaluation system first, send out their questionnaires, get back the information, and then start assigning the job classes on that basis. And there's nothing wrong with doing that. But I think the experience of unions has been, to some extent, that can result in ending up with multiple little job classes. And whereas your collective agreement before may have had 7 grades, you may now end up with 15. 7 different compensation categories. You may end up with 15. And listen, you may be happy with that. And if you're happy with that, that's great. But I think some people are finding that really will create difficulties for them when they get to collective bargaining again, and may create internal relativity problems for them. And I think given that experience, you may wish to think seriously before you start, rather than after you get your information back on your questionnaires, about what the job classes are. And you may, with a certain amount of information, be able to a large extent, define the job classes in advance and group the job classes in advance, so you don't end up, in the end, with a lot of little categories which you then have difficulty justifying in terms of similarity. So my advice to you on that point is I think we have some experience now. We should be trying to look to synthesize that experience to help us bargain better collective agreements while at the same time maintaining achieving the purposes of the Act.
Thank you, Cathy. I'm going to concentrate on one of the 4 criteria which are used to define job class. I think, as you already recognize, there are 4 items there: similar duties and responsibilities, similar qualifications, similar recruiting procedures, and the same compensation schedule, salary grade, or range of salary rates. And it is this final criterion that I'm going to concentrate on. It's one that initially I think many of us overlooked its significance, but it is turning out to be extremely important in many cases. For one thing, it is partly on that criterion that the demands for information by unions are being made, and it is partly on that criterion that the cybernetics decision rests. That is, there's a view that you cannot decide the job class, and in some cases, depending on the kind of evaluation system you want to use, you cannot come to grips with what that system should look like unless you have information about compensation schedules, salary grades, or range of salary rates. So that's a very, very important criterion. I'm just commenting on a few of Cathy's comments. My own experience with employers is that in terms of the management jobs, they are simply going by existing job titles or existing job classifications. And I have seen no attempt in any of the employers I've dealt with to combine managerial or directorial or vice presidential jobs and say they're all part of one job category. Despite my own views that was a viable option which ought to have been considered, people are simply not taking up that option. They're treating them as separate jobs, whether it's because they see the functions as so dissimilar or because in many cases they see the compensation rates as so dissimilar. They simply are having them evaluated as separate jobs. On the other hand, in certain job classes which are not just gender dominated, but almost 100% of the female gender, where there are a lot of people in those classes, because the questionnaires are sent out to everybody or to a lot of people over a number of departments, those jobs are breaking down from a single classification into potentially separate job classes. And the classic examples are the RNAs and the RNs. In hospitals, in the service units where agreements have been reached with the unions about the system to be used and the questionnaire to be used, the information coming back has led, very logically, to separate evaluation of RNA jobs depending on the department or the special area where they're working. That in itself may create problems because the RNA has traditionally been considered a benchmark job, not just in the hospital, but province-wide. And one can see potentially the province-wide benchmark rate for RNAs breaking down for a few years, until, of course, we eventually get back to a point where someone decides that all RNAs in the province ought to be paid at the same rate, which will naturally, of course, be the highest rate being paid to an RNA in the province. In those hospitals which are either non-union or where some agreement has been reached with the RNs, the same process is at work. The questionnaires are coming back on a departmental basis, and they're breaking out into separate job classes, which may or may not lead to a wage increase depending on how you band the jobs together. But you see both of those functions operating. On the one hand, the managerial jobs are not being combined. They're single incumbent jobs, and they're being treated as such. And on the other hand, the numerous female, or the job classes which have many, many females, overwhelmingly so, are breaking out into separate job classes. Now, Cathy mentioned that I was going to discuss with you a particular case to try and exemplify some of the interesting challenges about the term of job class. And I will do that. You must keep in mind that this is a matter which has been heard in full by the tribunal, and we are awaiting a decision with bated breath. It should be out, I presume, before Christmas. I have no doubt it will be. We've been promised. Some point shortly, what I have to say here may be totally academic. The issue concerns a wage grid, and that is the grid for teachers, and more specifically elementary teachers. Most wage grids or wage schedules that you see simply list a job, sometimes a job level, RT1, RT2, etc. And then there are increments depending on the number of years of service, and that's your wage schedule. A teacher grid is somewhat different. It is not simply a horizontal line in the collective agreement. It is a grid with two axes, one for years of service and one for the educational qualifications possessed by the individual. And on that basis, teachers, for the most part, are categorized in 7 ways. You have categories ranging from 1 to 7, depending on the level of education of the teacher. So a teacher's pay essentially consists of 2 components: the horizontal axis, the horizontal axis and the vertical axis, qualifications and years of experience. The Women Teachers Association of Ontario has argued in front of the tribunal that that grid does not represent one job class. It is broken down into 7 job classes. Each category of qualifications constitutes a separate job class. You must recognize that each qualifications category has a different maximum, and in fact, the qualification categories with less educational qualifications have not just a lower maximum, but they have fewer steps for service in the grid. The union has argued in front of the tribunal that because job class includes this criterion of same compensation schedule, salary grade, or range of salary rates, because each qualifications category has a different maximum and in fact a different range of rates for each year of experience, that each qualifications category constitutes a separate job class. And therefore a classroom teacher in the elementary panel, instead of being one job class, ought to be considered 7 job classes. And as I said, the decision is not out yet. It will no doubt be very interesting. This is a very significant issue financially, because potentially this decision will have a great impact on what the comparators are and whether or not the qualifications system for influencing the wage levels of elementary teachers will disappear or be radically modified. So on that one sentence, so to speak, or one part of that sentence, rests some very important decisions and some very important cost implications for school boards and obviously financial implications for teachers. Now, another issue where that criterion becomes very important is in looking at part-time employees. And to keep in mind that compensation under the Act is defined as all payments and benefits. It's commonplace that we have to take into account benefits when we're comparing the wage rates or job rates of different job classes. Now, when you have part-time and full-time employees in the workplace, there are a number of ways in which employers compensate the part-timers. In some cases, the part-time employee is on the same wage grid or wage schedule as the full-time employees, and in some cases, but very few, may actually have proportionate access to benefits. More common in the public sector, especially in the healthcare industry, is a provision giving part-timers a percentage in lieu of the benefits. However, there are many employers, especially in the private sector, who do not put their part-timers on the complete wage grid of the full-timers. They give them the base rate. And they may or may not give them access to benefits. And they very rarely give a percentage in lieu of benefits in the private sector. There are also employers who pay their part-time employees at a lower base rate than they pay their full-time employees. And if they do that, it's very unlikely that they give them access to the benefits or a percentage in lieu. So, if you have no male part-time job class comparable to a female part-time job class, and you then go and look in the full-time group of employees and you find a male job class which is comparable, there may have to be adjustments, not only because the wage rates are different, but because compensation includes benefits, there may have to be adjustments in the benefits. Now, it is arguable that compensation schedule doesn't mean wage and benefit schedule. One could argue that compensation may mean wages and benefits, but compensation schedule is something different. We'll see how that one goes. One may argue that a part-timer who is making the same rate as a full-timer is making the same salary grade and range of salary rates, and therefore there ought to be no adjustment. However, my view is that employers will be hard put not to take into account the better benefits given to full-time employees, where the only comparable for the part-time female job class is a male full-time job. And this creates problems, not just because it may cost money, which is always an issue for employers, of course, but because to give access to part-timers to the benefits on a pro rata basis, especially in organizations where they have quite a diversity of part-time employees. And that's true not just in the private sector, but in some public sector employers as well. They have such a hodgepodge of people, some who work this many hours, some who work more or less, and so forth, that administratively they see that as a real problem. As well, in the private sector, there is a reluctance to move to a percentage in lieu of benefits because they see that as leading to a result where the full-time employees are earning fewer dollars in their paycheck than part-time employees, which will create problems internally. In the hospital industry, the percentage in lieu of benefits has been such a part of the compensation and benefit pattern that people don't really regard it as a problem in that sense, that a part-timer may earn more per hour in some cases than a full-timer. But in the private sector, where percentage in lieu has not been traditional, that is regarded as a very serious internal problem. So we have some interesting issues coming up, resting simply on that one component of the definition of job class. Now, I will leave you with a parting thought. It turns out because Bernie took up so much time, we started late and we don't have a lot of time for questions, which really breaks my heart. But I will leave you with one thought. I'm sure that you've gotten the impression from most of, if not all of the panelists this morning, that because of the lack of definitions in the Act, and because some of the definitions are vague, to say the least, that there's a lot of room for creativity or argument, or some people may say it's all just a crapshoot. But I do leave you with the thought for the day. It was on my Murphy's Law calendar today, and I think it's quite apropos. It's a message to all lawyers. Always leave room for an explanation if it doesn't work out. Now, if you do have any questions, we'll actually deprive you of a few minutes of your lunch hour if anyone has the temerity to ask us anything.
Uh-oh, there's a bold soul over here.
I have a question between teachers.
Yes.
The grid is 7 categories, usually 10 years of experience, getting 70 different pay scales, running, you take the bottom of category 1 and you run the top of category 7. It's probably a factor of 3.
It's quite significant.
How in the world would you define, I'm assuming you take that as one job classification, which job classification you're talking about. You could either take it as 1, or you could take it as 7, or you could take it as 70. As many as 70. If you took it as 1, how would you determine how in your view would you determine the rate?
Well, the job rate is defined as the maximum rate. So I would take it as the maximum, yes. Now, the argument is breaking down in terms of FW is saying there are 7 categories, and they're allowing for the different rates for years of experience, partly because of one of the exceptions in Section 8, which specifically allows an exception for differences in compensation due to a formal seniority system. So their argument has been, that's fine, we don't mind that. Although they have a problem with the fact that the lower categories have fewer years, have fewer steps, which means the maximum is even lower than it would be otherwise. But I personally would say that the job rate is the maximum rate.
How would you compare outside categories? That's where I find.
Well, you see, the thing is that what may happen, and it depends on the nature on the school board because of their population, but if you have a secondary panel, the secondary job class or the secondary school teacher may be male dominated, and the rates for many school boards are equivalent at the max, or the difference is not that substantial. Or it may be that at the end of the day you say there is no comparator for the elementary, there's no male comparator for the elementary teacher. Keep in mind also that side by side with this issue of job class, there is another issue, and that is whether or not there are 1 or 2 bargaining units in the elementary panel. Because you have 2 affiliates or 2 unions. You have the male teachers union and you have the female teachers union. And one of the arguments that was being addressed in this case was whether or not there are 2 bargaining units or 1. And if you have 2, then your comparisons are quite easy. If you have 1, it's a little more problematic. Don't forget that at this point, no evaluation or comparison system has been devised. They haven't got to that point yet. The issue is simply what is the job class and what is the bargaining. Oh yeah, but there's a lot of employers that aren't going to have their plans posted on January 1, 1990. I know a number of them personally. I think that's it, Cathy.
That's right. It was so lucid that no one could possibly ask it.
That's right. I think it's appropriate. We're all wearing black and blue.
very much, Cathy and Janice. We now are finished the morning session, and you are free for lunch to go wherever you wish until 1:30. The faculty for this session are invited to come to a separate but different and still equal lunch up in the barristers' dining room. So we'll see you back then promptly, please, at 1:30. Yes, you may leave your materials here. At the end of this process, whether it be in an hour and a half or in another 3 years, we may have an answer to this question. To begin to pose the questions, we have a panel today consisting of Dr. Nan Weiner, who is the acting director of the Policy and Research branch of the Pay Equity Commission. Nan is a graduate at the University of Minnesota, and she has had extensive experience in compensation and human resources. And she has completed or was instrumental in working on the predominantly female study and in developing the policy options with respect to that aspect of pay equity. Paul Waring is a partner at the law firm of Shibley, Wright and McCutcheon. Paul represents employers in labor relations. He has been spending a tremendous amount of time in pay equity, and he has occupied approximately 50% of our hearing days. And so he personally he has. He obviously has lots of experience with respect to the issues in pay equity, and in particular in litigating cases before the tribunal. Laura Trejok is an associate in the law firm of Cornish and Associates. She's a graduate of the University of Toronto, and she and her firm represent labor law representing trade unions. Laura is quickly making a run with Paul for the occupying of the amount of hearing time before the tribunal. Laura, Paul, and Nan have all written extensively in the area of pay equity, and Nan has agreed to begin the topic of myth or reality for gender neutrality.
Thank you. My background is compensation, so that's where I'm coming from. And I was asked to be on this panel because it was felt you needed to know something about job evaluation and then about gender neutrality in job evaluation systems. Time is limited, so I'm going to be very sketchy about job evaluation and go into more detail about gender neutrality. If you're interested in more information about job evaluation, pretty much any standard compensation textbook will have a chapter or two, and it will spell out the basic methods and so on. One of the things that's most exciting about pay equity is the way it's challenging and making us in the compensation and human resource field rethink job evaluation. Now, job evaluation is not the only way to do gender neutral job comparison, but it's one way. So it's one of the ways that's been around for a while in terms of comparing jobs. And so it's one of the ways that many, particularly large organizations which are familiar with it, are turning to. One of the things that surprised us at the commission is it's one of the ways that even smaller organizations are often turning to, in that they seem to be saying, look, let's go with something that's tried and true, that's been out there. Let's not reinvent the wheel. There is some reinvention that's going on that, as I mentioned, is really exciting, but it's being done within the framework of the traditional systems. Basically, job evaluation is a process similar to one I'm sure all of you have gone through at some point in your life, and that is you want to compare something. Maybe it was job offers when you first got out of school. Maybe it was where to take your summer holiday. But when you have a decision like that, what we often do is we set up a series of criteria, and in job evaluation we do that very explicitly. Those criteria are spelled out in some detail, and then information is collected on each. Instead of alternative, it would be a job in this case. Each job description is then applied against all of their criteria. And some decision is made as to which job is worth more than the other jobs. The most typical kinds of systems, in terms of their use, not necessarily in terms of which ones are better, well, the most common kind of system is a point factor system. And that means that every time you compare a job against a criteria, you note how it did against that criteria by giving it some points. And then when you've finished comparing against all the criteria, you simply add up the points. One of the problems with a point factor system is that it gives out all of us a false sense of security. It gives us a sense that we've measured something objectively. Let me tell you that there is absolutely nothing objective about job evaluation. It is a totally subjective process. And that's an important thing to keep in mind at all times. Now, we make a lot of subjective decisions in our lives, and we make most of the most important decisions we make in our lives are subjective. Has anyone ever fallen in love and gotten married? That was a fairly subjective decision, I will submit to you. Even our career decisions are often quite subjective. So I don't think we have to apologize for doing something as important as deciding on the pay for jobs in a subjective manner. What job evaluation tries to do is be systematic, and that's where its strength lies. So it wants to make sure that we've spelled out ahead of time what the criteria are, not that we make them up as we go along. And it wants to make sure that we've evaluated each job against each criteria. So being systematic is very important. The two, as I mentioned, the two most common systems we're running into in pay equity are the point factor system and something called the policy capturing system, which has a statistical base. And that, again, doesn't make it any more subjective. I think there's the danger that if you tell people, well, we ran this through the computer, that therefore they'll think the answer must be objective. The whole process is subjective. All the decisions of what information to collect are subjective. You then throw all of that in a computer, and you're only going to get out a reflection of the values that were put in. So you need to be aware that numbers, computers, don't make it an objective process. They just systematize how you make that subjective decision. Consultants have been in the business of selling job evaluation systems for about 40 or 50 years. Most of the systems were developed initially in the 30s and 40s. They were developed for manufacturing, industrial jobs, typically heavy manufacturing. These tend to be male-oriented jobs. There are some fairly old clerical technical systems, but they followed the industrial systems, and so what you find is an awful lot of commonality among the systems. Each system that's been newly developed tends to look at all the other old systems, and so there's a great deal of similarity. So one of the first challenges of pay equity to job evaluation systems is to ask us to rethink some of the very kind of fundamental criteria, way we've defined skill, effort, responsibility, and working conditions. And let me say that the consulting community is not necessarily jumping up and down about this opportunity to reevaluate their systems. They've invested a great deal of money, they have a great deal of experience in using their systems, and it's not financially in their best interest to rush out and redesign them or change them. In the job evaluation field, the concept of new and improved has never gone very far. It's been just the opposite. It's use our system because it's been around for 40 years, therefore it must be reliable. What we're saying is, yes, maybe it is reliable, and so the gender bias that's been in it from the beginning is still in it, so maybe you better look at it again. So you're going to find consultants themselves trying to understand the concept of gender neutrality, and quite honestly, we don't know everything there is to know about gender neutrality yet, so it isn't as if they're just in the dark. It's that it's a developing field. What do we mean by gender neutrality? Well, essentially gender neutrality is the absence of gender bias. Kind of a circular definition, but probably the best one we have. It's important to remember that when we are looking for a gender neutral result in the salaries associated with jobs, we have to look beyond the job evaluation system or any other kind of comparison system. That's only one of three aspects that goes into the gender neutral results. The first is the job description, the information on which the evaluation is made. If there is gender bias in that, there's every reason to believe that the results will be gender biased. And it's very easy for there to be gender bias in the way we write up job information. One of the problems with women's jobs is that we think we know what they are. Anybody have any contact with secretaries? Okay? We think we know what a secretary does, and we do to some extent. But having worked in the human resource field for 20 years, if there's one lesson I learned, it's when you start to look at a job in depth, there's always more to it than there is on the surface. And so if we think we know what a secretary's job is, we're less likely to ask the questions that we would have to ask about a job with a job description we'd never heard of before. So we're less likely to probe, we're more likely to rely on our assumptions and our stereotypes. And because so many jobs are associated with a particular gender, those things get mixed up and confused together. We have an overhead we use at the commission that shows two typical job descriptions. One is a secretary, and the job description says that she files, types, and answers the phone. And we have a job description for a security guard, which goes on for 2 paragraphs. Now, if those were the 2 pieces of information you had to evaluate, it's pretty obvious which one would get evaluated higher, simply because of the amount of information that's there. So men's jobs are more specifically defined. We have to ask more questions about them often. That may lead to more complete job descriptions, and that may be a problem. Obviously, the system can be gender biased, and that's what I'm going to spend time talking about today. But let me warn you that a system can be gender neutral, and it can be applied in a gender biased manner. You've got usually a group of people in a job evaluation situation reading job descriptions, looking at the factors, the criteria that they're evaluating jobs against, and making decisions. Now, as the organization gets smaller, it gets harder and harder to look at just the job and to forget the incumbent in it. So it is not unusual, everyone who's been in job evaluation has a story like this. It is not unusual to have a group of people sitting around looking at a job description and for someone to say, oh, well, this is Sally's job. Well, Sally just got married. She doesn't need any money. Right? Now, that has nothing to do with the job, nothing to do with anything relevant to job evaluation, and those kinds of things are said out loud. Who knows what goes on in people's minds that they don't even say that influence their decision. So a gender-neutral tool could be applied in a gender-biased way, and that's obviously has to be watched for. In looking at systems themselves, as I say, we're evolving what is gender-neutral. The first thing that has to be said is you cannot talk about whether a system is gender-biased or gender-neutral in the abstract. You must apply it to a set of jobs, because one system may be gender biased for one set of jobs but gender neutral for another. So you always have to say, tell me the kinds of jobs this is going to be used on, and then keep that in mind as you're evaluating the jobs. Some of the principles that we've built on from some of the work that's been done is be explicit. If you're not explicit, then each individual evaluator can bring to the job evaluation process more easily his or her own biases. If you're explicit about what you're evaluating, at least that has to be discussed and talked about, and if people are deviating from that, it's easier to see it. Ensure inclusivity. This means that because job evaluation systems were traditionally designed based on industrial jobs, they may have missed things that are commonly found in women's jobs. And 2 researchers in the U.S. did a study and looked at about 18 job evaluation systems. They came out with 100 pages of factors in these 18 systems. They still found a whole set of things typical to women's work that was left out. And we highlight these in our booklet, How to Do Pay Equity Job Comparison, which you have in your materials. So you need to think about the work that women do, and is there anything relevant to this work that isn't going to be met, isn't going to be found in the criteria that are set out in the job evaluation system, and those have to be added. Consistency is important. Some of gender bias is a matter of seeing something in men's jobs but not seeing the same thing in women's jobs. So we see the heavy lifting that goes on in a laborer's job, but we miss the heavy lifting that goes on in a child care worker's job. If you value lifting, then value lifting in both jobs. Check the results for patterns of gender bias. To some degree, it's very difficult to assess if you've achieved gender neutrality until you see the results, and then you sit down with them and you say, does this make sense? Can we see how we got there? Is there something out of whack? There are some ways of checking certain parts of the process for patterns of gender neutrality as you go along also. And a final thing, and I must say that in speaking to this audience, I think this is very important. My sense is that lawyers are lovers of the word, and your business is words, and you get into little words and what they mean and how that may change the meaning of a sentence. And sometimes we lose sight of the forest. I sometimes say we lose sight of the forest for the leaves. We get into such detail. We need to remember what pay equity is about and why we're doing this. Many of the questions we get on benefits, for example, show a great deal of thought, but they've ignored the overall spirit and intent of the legislation. Sometimes it's useful to just back up and say, why are we going through this exercise in the first place? I don't have much time left. I have in my paper a number of examples from various job evaluation systems which are suspect, at least on the surface, of gender bias. And I say suspect because, again, we cannot say something's gender biased or gender neutral until we know the exact set of jobs, the range of those jobs, and so on. So these are just some things that we've seen. We at the Commission do look over job evaluation systems and give feedback to the parties if they ask. We obviously don't bind the tribunal in any way, and ours are more to highlight things and get feedback to the parties. They then can decide if they're going to make changes or not. But as I say, the first thing you have to do is decide the jobs on which they're going to be evaluated. It sounds very simple, but a second step is to ensure that the 4 factors, skill, effort, responsibility, and working conditions, are in the system. There's at least one very long-term system used for clerical and technical jobs that doesn't have an effort factor. Well, that's clearly in violation of the Act. Again, old term management system for a long time didn't have working conditions, so the Act is very specific that those 4 factors must be there. Now let me say that a particular sub-factor, and by sub-factor I mean it's all very nice to talk about skill, but we have to get a little more definite than that. Are we talking about knowledge? Are we talking about dexterity? Just what aspect of skill are we talking about? Those sub-factors, there can be discussion about which category they fall under, but it should be clear that there's at least one sub-factor under each of the 4 main factors. The weightings of the factors. Weightings of factors are one area we get a tremendous number of questions on. Weightings of factors essentially says, do you value skill, effort, responsibility, and working conditions equally? And if you do, then you've weighted each of them 25%. But in most point factor systems, the answer is no. We don't value those 4 factors and the sub-factors under each equally. We want to make some distinctions. And that, in fact, is one of the prime advantages to having a point factor system. It allows you to weight factors differently. There is no magic to weighting factors. The weighting of factors, again, is a value decision. It's a subjective decision, obviously one that needs to be negotiated by the parties under pay equity. But one of the things that's become quite obvious to me is that most of the factors in most systems have, at least on their title, a male bias. And this comes out of a study that was done in the United Kingdom. We, again, talk about it in our booklet, How to Do Pay Equity Job Comparison, which found that certain factors tend to favor male jobs, certain factors tend to favor female jobs. Now, that doesn't, in and of itself, to me, make a system gender biased if it has more factors that favor male jobs. You have to look at the context. I was looking at 2 systems. One was a plant system, heavy manufacturing. About 63% of the factor weights favored male jobs, but that seemed to make sense. It was when I looked at a companion system that was for clerical and technical jobs, and 37% of the factors favored male jobs and only 7% favored female jobs. That seemed less appropriate. Again, how you define factors more than how you title them is what's critical. A lot of disagreement about factors. I think we're going to see some tribunal cases on that. The next step in assessing gender neutrality is simply to read through each factor definition, each level of each factor, those are the criteria, with a critical eye. And what I usually do is again, depending on the kind of jobs that are going to be evaluated, I have a few female jobs in mind, and I would say, well, where would this female job go? Where would this one go? And can I evaluate that easily? Is it clear to me where this job goes vis-a-vis male jobs? Some of the things to look out for: inconsistent conceptualization. Most systems have a factor called complexity, and complexity is a garbage can factor. They've got everything but the kitchen sink in there. They've got judgment, complexity, routine, and you start reading through this factor and you realize that at the various levels it seems to change in what they're measuring. Is that gender biased? I can't say it is for sure, but it might have a gender bias impact. There should be a consistent conceptualization of each factor. If you decide what you're measuring, make sure you're measuring it just simply at different levels all the way through. One of the small thing is very often there will be examples of male jobs throughout the job evaluation system and few examples of female jobs. Or the female examples seem to be tagged on at the end. Easy thing to do is if you're using examples of either kind of work or job, put them in alphabetical order. It's gender neutral. But this sort of you go on, you read 17 examples of male jobs, and then there's 2 examples of female jobs at the end. You have a sense they're not as important, they're not as meaningful somehow, they're an afterthought. Some of the other examples, specificity. Some systems will be very general, and then they'll give you a very specific example, like manual skill goes here. Well, that specificity in and of itself is a real clue to how to rate manual jobs, but it may not have something consistent in terms of where female jobs should be rated. One of the problems in many systems is too few levels for the kind of work that's being done. One system has only 3 levels of interpersonal skill. Think in a law firm. You've got people, I suspect, in the mail room. You've got a clerical staff. You've got lawyers. You've got senior partners. Can you evaluate all those jobs on just 3 different levels of interpersonal skill, or do you need more levels? Law firms, have very verbal, a lot of interpersonal interaction. Now think about a hospital. Is 3 levels of interpersonal skill enough to evaluate from jobs where there's absolutely no patient contact to jobs where there's some patient contact, or jobs where there's only contact with persons who are well, the family of the patient, all the way up to people who are having to tell patients that they're dying or their children are dying, and yet systems are trying to evaluate all of that on only 3 levels. Missing factors, as I mentioned, is always a problem. One of the biggest problems is overlap, measuring the same thing with different factors. Often these overlap factors seem to be things that would be related to men's jobs. One system I saw had about 6 factors that really measured managerial level, responsibility for finance, accountability, risk-taking, and it was measuring the same thing over and over and over again. That may fool you into think you're measuring different things when in fact you're highly weighting a particular situation. If there's time, I would recommend that when you have a system, or you've selected a system, or you're trying to compare 2 systems, that you field test a few jobs on the system, that you give people a chance to try it out. Reading through job evaluation systems it can be a tricky business. They can sound like they make sense, they can sound logical, but the real test is if you take a job, can you apply it? And when you're field testing, be sure to take some female jobs and some female jobs and some male jobs. It doesn't make a lot of sense to have a system that works beautifully on all the female jobs, but can't evaluate the male comparators or vice versa. In conclusion, let me say that one of the trickiest things about negotiating a gender-neutral comparison system is, unlike other kinds of negotiations that have gone on, where one party comes to a table, let's say it's a wage issue, the union will come to the table and it'll aim high, management comes to the table, it aims low. Both parties know that over time they're going to work and hopefully reach a settlement somewhere around the middle. In job evaluation, it doesn't quite work like that. If one party comes to the table with one plan and another party comes to the table with another system, it's pretty hard to compromise and say, well, we'll take 2 factors out of yours and 1 factor out of ours and put it together. It seems to me that it makes a lot more sense for the parties to sit down and first discuss the criteria on which they would select a job evaluation system or their job comparison system. That they should talk about what they want that system to do, a little bit about what they want it to look like, maybe some of the factors that they all agree absolutely have to be there. Then they can try either systems that they kind of have in the back of their mind, or can look at a whole set of systems against these criteria. But it's pretty hard to negotiate if each party comes in saying, this is the only system that we'll consider.
My part of the presentation this afternoon will be to deal with some of the things that Nan has been speaking to you about in the context of negotiations. Now, first of all, it is perhaps ironic that I'm here speaking to you about negotiations when you consider the introduction that Beth Symes gave to me with respect to the amount of time I spend presently litigating this statute. I want everybody to know that I would far sooner be negotiating the aspects of achieving a gender-neutral comparison system than in the litigation that I am now embroiled in. Having said that, I'd like you to keep in mind the primary section of the legislation with respect to the responsibility for negotiation. I'm referring to Section 14. particularly Section 14.2. I understand that the section has not been reproduced in the materials. If I may, I'll just take a moment to read this section to you to give you a sense of what I'm speaking about. 14.2 is as follows. The employer and the bargaining agent for a bargaining unit shall negotiate in good faith and endeavor to agree before the mandatory posting date on sub A, the gender-neutral comparison system used for the purposes of Section 12, and sub B, a pay equity plan for the bargaining unit. This section in the statute is your primary section dealing with the responsibility to enter into negotiations. It is not, however, the only area of the Act that invites and in fact requires some attention to negotiation. In addition to Section 14.2, you should consider that there is a requirement to enter into a form of negotiation, or in fact negotiations, with respect to female job classes, male job classes, and the application of the definition of job class. All of those definitions you will find in Section 1, Sub 1 of the Act. But I ask you not to overlook the necessity to fully appreciate what a job class means in the context of your negotiations for a gender-neutral comparison system. The third matter that you should contemplate for negotiation is a matter that is silent in the Act with respect to the necessity to negotiate, and I suggest to you it will require negotiation. That is the application of the rates and the timetables for wage adjustments. If you refer to Section 13, Sub 5 of the Act, you will see that there is a requirement to make adjustments where necessary and to allocate 1% of the total payroll within 12 months of the posting date. The Act is silent on allocation. Therein lies the necessity for negotiation. What I'm speaking about here is the situation in which you will find an employer having more than one bargaining unit, to say nothing of bargaining units and non-union personnel within the establishment. Because the Act is silent on allocation, I suggest to you that the employer be very cautious with respect to allocation, and that the employer invite representatives of the bargaining units as well as the non-union personnel to negotiate how you will allocate the adjustment monies. If you fail to take this into account, if you as employers merely allocate whatever you feel is appropriate in the form that you feel appropriate, you will run the risk of being on the receiving end of a complaint, because there will be some concern as to how you have broken up this 1% of your payroll, and you must do it in a manner that will satisfy all the parties. So that I urge upon you to keep that in mind when you are contemplating the allocation of the 1% of the payroll. I would also remind you that, in fact, only the unionized setting requires negotiations. Now, the requirement for negotiations is as stated in Section 14, but you will find reference to the non-unionized setting in Section 15. Section 15 speaks to the situation where there will be no bargaining agent and where you, as the employer, must, however, come up with a plan and post it within the mandatory time limits by the mandatory posting date. I would also remind you that the employees in the non-unionized setting have the mirrored rights of employees represented by bargaining agents to seek amendments to that plan and ultimately to have redress before the hearings tribunal if they do not accept the plan that you have posted. And rather than going into all those details with respect to the process, I ask you to keep Section 15 in mind, because 15 and parts of 16 address that process for non-unionized employees. I was interested to hear Dr. Weiner discuss the necessity to approach the bargaining as a problem-solving process. I would certainly endorse that in a perfect world. Regrettably, and this is not in any way a criticism of the comment, because I do support it, but regrettably, what we are dealing with are parties coming to the bargaining table with the benefit of having been promoted by various job analysis firms, consultants, etc. And when they are coming to the table, they already have some idea of a system that they would like to see implemented. This goes both, by the way, for employers and unions in my experience to date. So that I would suggest that the practical situation at this point in negotiations is that the parties will come to the table with some ideas with respect to the type of system that they would like to see implemented. And that is a good thing in my submission to you, because in fact that means that the parties have undertaken a certain amount of education about this goal in the Act. And it is far better that they come to the table with some educated view as to how to succeed, rather than merely coming to the table without any sense of direction. With respect to the sorts of proposals that you might expect, I would suggest that there be a very close attention to tabling written proposals at each step. Now, those of you who practice in the area of labor law will be well acquainted with the ordinary course of bargaining and the filing of proposals and the discussion of those proposals. I cannot stress too strongly the necessity for using written proposals at every step of the negotiation process. This will ensure, I hope, that there will be less misunderstanding between the parties with respect to their positions, but more than that, it will allow each side to fully appreciate the intent of the other side in relation to its goals and where it sees itself going in the negotiation process. The second point I would like to stress to you is that you maintain very precise minutes of negotiation. Regrettably, the process takes quite some time to achieve, and if you end up before the tribunal dealing with a complaint or a reference, you will want to have the benefit of the experience at the table in a strong way. You ought not to expect to rely upon your memories, because your memories will be somewhat cloudy by the time you end up at the tribunal, and that will not serve your purposes in representing your interests. So that rely upon minutes of negotiation. I would urge you to circulate those minutes to each other, that is to say, union to management and management to union, again to ensure that there will be the minimum of misunderstandings in this process. With respect to the use of a consultant, let me first commend to you the comments that Nan made to you, and in fact are in her paper. You'll find it at page 14 and 15 of her paper. She lists considerations to be followed in the selection of consultants, and also the type of thing that you should be asking consultants about. I think it's extremely important that before you commence using a consultant, that you are educated with respect to their product and what they are able to undertake with their product. Now, with respect to using a consultant thereafter, my advice is simply this: a consultant cannot be a spokesperson in the negotiations. That is absolutely contrary to what is contemplated by the Act, and you will also bring about problems for yourself because of the perception that the other side will have with regard to what the consultant has to say. If a consultant is at the table at all, the consultant must be perceived and must be used purely as a resource person. Now, speaking from the employer's perspective for a moment, employers ought to interview consultants if they think it necessary after considering their in-house expertise. Now, depending upon the size of the employer, that employer may or may not have all sorts of resources to rely upon to deal with these issues. But again, as Nan has pointed out, these issues are brand new. And you may well find yourself with in-house expertise, but expertise that does not fully comprehend the requirements of the Act, and particularly the need to demonstrate the lack of gender bias in any system that you might want to propose. So if you come to the conclusion that you might require outside help, then by all means, go and get it. In some of the cases to date, unions have taken the position that it was incorrect for an employer to unilaterally hire a consultant in assisting in the process. Now, depending upon how you use the consultant, the union may or may not have a point to be made in that allegation. I hearken back to what I said a moment ago. Your consultant is there as a resource person for whomever hires that consultant. The ideal situation would be to have both the union and the employer agreeing on the retainer of a consultant to advise the parties and to assist the parties in the implementation of some system. That's the ideal situation, and I suggest that it might be hard to achieve because of the fact that so many of the bargaining agents in the province at this point, certainly in the public sector, have got an idea of what type of system that they want in advance of bargaining. And that is not a criticism of those bargaining agents, it's simply a fact of life. Hence, the agreeable or the desirability of hiring a consultant to be used jointly may in fact not be achieved. If you have your consultant, if you as the employer hire a consultant, you should not go beyond, in my suggestion, you should not go beyond an introductory retainer with that consultant, because you don't know at the beginning of the negotiations what kind of a system you're ultimately going to have. So if the consultant comes along and sells you a product that runs from beginning to end, that is to say from the outset of evaluation through the assignment of the weights to the implementation of a plan, then in fact you may be buying something that you can't use in any event, because your negotiations will govern what will be used ultimately. So I would suggest that you speak to a consultant if you feel it necessary and ask that consultant to apprise you of the recommendation that they would make to achieve your responsibilities under the Act. But you ought not to go any further than that at that point. If you conclude that what the consultant is telling you from your reading of the legislation and your own sense of what has to be done, if you conclude that what the consultant is saying is useful, then you may go to the bargaining table with that sort of a system or that type of proposal in mind. But the key in negotiation is that both parties must attend at negotiations willing to create a system that they both will be happy to live with at the other end. In choosing a system, I would ask you to keep in mind three things. First of all, and the primary issue clearly, is to be able to, at the end of the day, be assured that the system is absent gender bias. Now, as lawyers, you all should be aware of the necessity to be able to prove that the system is absent gender bias. It's one thing for the consultant to give you a presentation and make assurances from the consultant's perspective as to what this product will be able to do, but there is some onus upon you, if you become counsel in these matters, to think down the road so that you will be comfortable in representing the client with respect to what this proposal can do ultimately. The second matter you should keep in mind in the selection of a system is the time required to implement the system. As you should all realize by now, mandatory posting date for public sector is January the 1st, 1990. If you represent clients in the public sector who are not through their negotiations at this point, I suggest you will not make it, and you will have to be prepared to make your position and your apologies to the Commission, because the Commission is taking a very strict view as to the requirement to post. And I can only suggest to you that if you are conducting negotiations presently, and if they are moving along, then that is a positive thing. Clearly, if you miss the posting date through just a failure to succeed, but your intentions are well-founded and both parties are working together, I would hope that the Commission would take that into account in assessing your diligence and assessing your commitment to the Act. Nonetheless, time is a very important factor. Those of you who are not facing the January 1st 90 deadline, those of you who are dealing with the private sector in smaller numbers, of course you will know that your deadline will be January the 1st, 1991, and clearly if you have not begun to negotiate, you should be doing that right now. I think, again, Nan makes the point in her paper, it takes longer than you think, and speaking from my own experience at this point, clearly it is not unrealistic to expect that it could take you as long as 6-7 months to negotiate. And of course, that's merely a factor of the parties being able to get together and the parties being able to digest what is being proposed. You all know that we don't meet on a daily basis when we negotiate, so in fact, if you can grab 5 dates for negotiation of this, you might well end up in dealing in 6-month blocks of time. The third matter to take into account with respect to the selection of a system is the cost to implement that system. Now, I don't want to be heard to say that a defense to implementing pay equity is, I can't afford it. That is not the case. But you will know from your own budgetary constraints and your own experiences that you will have certain amounts of money to deal in the negotiation process, the time spent, etc. But more than that, the cost of some of these systems may be more than what is necessary to achieve the purposes of the Act. You must keep your mind strictly on the Act. To give you just an example of what I mean, the Act does not require that there be job descriptions for all your employees. Nonetheless, many of the systems that the consultants are proposing incorporate a job description step. Now that's all very helpful to the employer, and certainly will be something that the bargaining agent would be interested in seeing as well. But the fact of the matter is it's an added cost, and you don't necessarily have to take on that cost in achieving the purposes of the Act. Something that may come up in your negotiations in the unionized setting is the payment to the union committee. This comes up in our regular negotiations of collective agreements as well. And many of you will find that you have this in your collective agreements now, the requirement to pay committees to negotiate. You will be invited to pay the committees that meet with you on pay equity you will be invited to pay them to negotiate, and I would suggest that that is a consideration that you pay very close attention to in your negotiations, in your preparation for negotiations. Let me say a little bit about the role of review officers. I know that this is part of another presentation, but I would just like to give you a small insight into how the review officers should be able to help you in negotiations. Originally, my understanding of the role as contained in the Act was that they be there to assist the parties. In fact, the Commission has issued a newsletter to the effect that they see the review officers as being both conciliators and mediators. And if you read the Act very carefully, you would come away with the impression that they should also be decision makers. Now, regrettably, to date, it would appear that review officers are not achieving the goals, if you will, that the Act set for them. And I suggest that's regrettable, because this whole process should be a process of negotiation, and the participation of a review officer should assist in the expeditious negotiation of the issues. Nonetheless, to date, the review officers, who have been out in the field working very diligently, have not, in my opinion, been able to succeed in the way that the Act contemplated that they succeed. I would ask you to keep in mind a very early decision in the Haldeman Norfolk case referable to the role of review officers. In the case, and I'll refer you to Section 25. Section 25(1) of the statute is as follows: the hearings tribunal shall hold a hearing under sub A if a review officer is unable to effect a settlement of a complaint and has not made an order under subsection 24 sub 3. The tribunal has ruled, and I understand that this ruling has been followed in some subsequent cases, that 25 sub 1A should be interpreted as follows, or should be read as if the following words were added. If a review officer is unable to effect a settlement of a complaint within a reasonable time and has not made an order. So if you find yourselves negotiating, and if you find yourselves with the assistance of a review officer working toward a goal, but you have not had an order out of the officer, you may find the other side moving to have a hearing before the tribunal, and thereby, in my characterization of it, going around the negotiation process. I say that's regrettable. I also will keep in mind that it is extremely important that we conclude our negotiations in an expeditious fashion because of the mandatory posting dates. And I am fully aware as to why the tribunal made its ruling wherein it added those words within a reasonable time. Nonetheless, I would suggest to you that this could be abused in certain instances, and I raise it with you only to make you aware that if you are negotiating and you have review services assisting you, do not conclude that by doing so that you will be avoiding a hearing at that stage in any event, because you may find yourself in front of the tribunal notwithstanding your best efforts to continue the negotiation process.
I might just jump here and say that the review officers settle 80% of the cases that have been closed to date. So there is quite a bit of settlement going on out there.
I'm aware of that statistic, that statistic was known to me as well. My comment, however, goes to the quality of the negotiations that we are encountering with respect to the participation of the review officers and the, in some cases, reluctance of the parties to follow the orders of the review officers. I'm sorry. Sure, Beth, that's great. Forgive me, I've run over. I would only conclude by urging you to be particularly careful with respect to the selection of assistance from a consultant, and that you ensure that your consultant meets the requirements that are set out under the Act. Thank you.
I'll try and be very brief and cut out a lot of things that Paul touched on. The first thing that I wanted to tell you was to keep in mind if you end up having to litigate either gender neutrality or bargaining in good faith, or both of them together, and I'll talk about how they mesh in a minute. Keep in mind that this is a specialized tribunal, and they probably know a lot more about this act and the way it works than you do. So you have to do a lot of work before you get there. There is a lot of information out there about gender neutrality and job evaluation systems in the traditional sense. There is also a lot of information about what people are doing in the States, at least in terms of gender neutrality with the traditional systems. And there is some information about how to bargain, for instance, ranking. It's important that you have a pretty good understanding of what the issues are before you try to say that someone's plan is gender biased, or that you try to defend your own plan as gender neutral, because it's extremely specialized, complex, and people have PhDs in this stuff. So it's somewhat difficult for us as lawyers just to jump in there without preparation. The other thing to be careful of is whether or not is relying on a lot of the papers that, for instance, Mary and I have written and other people have written about this act, because mistakes have been made. And we didn't know how it was going to work out. So don't think just because you read even some of the information in here, I haven't read it all. There could be errors. Everything is new. So you have to think it all out for yourself. As far as I know, nobody, except in Ontario, and there are no cases on it, is actually litigating the gender neutrality of job evaluation systems. Now, there are people working on it in the States, but as far as I know, they're not using it in litigation the way we use it. They use it to prove discrimination, but they don't use it in the way we're trying to use it to determine what adjustments are going to be. So there really isn't anything that you can rely on in terms of litigation precedents. And it will be a while before there is a precedent from this tribunal. There is one case that is on gender neutrality. That's about, well, the union has finished its case, and it's taken quite a long time to get this far. So I think you're looking at several months anyway before there's anything on it. Paul touched briefly on the role of a lawyer in negotiating a gender-neutral comparison system. at least from the union perspective, and it may be different from management as it usually is in negotiations, we're not being used to negotiate usually. We're getting, behind the scenes phone calls and so on, would this comply with the act or that kind of thing. We're brought in usually at review services stage. And I probably don't have to tell you this, you're all, I'm sure, will look after your own interests, but be careful about the client that wants you to guarantee a plan that they're proposing is gender neutral. Of course you can't do that. You can only, at best, if you've educated yourself as to what a gender neutral plan might look like or what the issues might be, flag problems. And then after that, you're going to have to find out from your client what they have done to ensure that the plan is gender neutral, because we don't know at this point how gender neutrality and good faith or bad faith bargaining is going to mesh. But it's, and I'll get into that in a minute, but at the very least your client, the employer, not the consultant, has to ensure or has to have taken steps to ensure that it's gender neutral. And plans can be tested. In fact, I think if you're going to go with a job evaluation system, that is not a ranking, a comparison, that kind of thing, but an actual job evaluation, a priori or policy capturing, actually an a priori policy capturing wouldn't have to be tested, but an a priori system would have to be tested. If you're going to take it as far, if you're going to end up at the tribunal, I think you're going to have to test the plan. So what amounts to compliance and bargaining in good faith under this act? You probably think that you know what bargaining in good faith is because you've done lots of labor board work or at least studied in that area. The labor board jurisprudence, it looks to me at this point, will take us only so far because it only deals with process. And this act requires that that certain content be included in the agreements that you come to. So I don't know what good faith is in that kind of a situation, and I don't think anyone does. We're going to have to think about it, make arguments, and the tribunal is going to have to decide. There are, as far as I know, as far as I can recall, no review service orders that find bad faith. And I could be wrong on that. Have you seen one? No. I haven't seen one. That's not to say that they don't make orders in cases where bad faith is alleged, but I can't remember seeing one where they actually make a finding either on that. So we're thinking of a lot of, whilst we're trying to work it out for a lot of levels, is it bad faith to propose a gender bias comparison system? And if it's not, how much do you have to ensure? I mean, what does the employer have to have done to ensure that it's a gender-neutral comparison system? Is it enough to take the stand and say, well, my consultant guaranteed me it was a gender-neutral comparison system? Or does the employer have to have, or the union, because unions are proposing plans as well, have to have educated themselves to a certain extent and investigated the plan on their own? Or had someone else look at it, and we just don't know that. And then another related issue in terms of gender neutrality and bargaining in good faith is disclosure. Consultants don't necessarily want to release, particularly to the unions, but even I think sometimes to the employer, I'm not sure about this, all the information about their systems because they're like trade secrets to them. But they have a computer base and they have a variety of factors and so on. They don't always want to tell you what they all are, but it's very hard to expect anyone to agree, that's employer or the union or both, to a system without seeing all that. And in the past, the consultants could say, look at my proven track record, we did a plan here, here, and here, call them and see how satisfied they are. But those weren't necessarily gender neutral job evaluation system because there was no requirement. There's nothing unlawful about a gender biased job evaluation system unless you're trying to use it for the purposes of this act. So that's a problem, and it seems to be coming out quite a bit. The other problem is an employer's disclosure of wages. there has been a ruling by the tribunal, I'm sure you're familiar with it, that a union needs to know the compensation structure in order to decide or to make a determination about whether or not it will agree to a compensation system an evaluation system that's suggested. And we also need, the way it also fits in here is what Ms. Baker was talking about this morning. In order to test an a priori system, for instance, one thing you need to know is what the jobs are that you're going to compare. Now, unless you're going to compare all the jobs in a workplace, you probably have to know, have a pretty good idea of what your job classes are before you decide, you can figure out whether or not a proposed a priori system is gender neutral. Because the key, and Nan mentioned it briefly, but from what I've been hearing from the experts over and over again, the main thing, although there are a lot of other factors involved, but the main thing with an a priori system to ensure gender neutrality is to make sure that all the content of the jobs you're going to compare is in there. And that's one of the major problems, so that's why with the traditional system, so that's why there's a lot of focus on that. But in order to, you have to know then what the jobs are that you're going to compare. And as Janice said this morning, one of the factors in determining the job class is the compensation schedule. So that's a place that we're getting into trouble. I mean, that parties are faltering in their negotiation right at the start because they, in some situations, don't feel, that is, the unions don't feel that they have the information they need. And that's completely aside from any issues about, a level playing field or anything like that. That's right in the act, and it's a problem because, well, employers don't like to tell people what their management makes. Whether or not you agree with that, they often don't. And the other problem is that women in management positions may also, their salaries may also be lower than they should be because of historic gender discrimination in their wages. And, they don't want all this information out there. I have a lot of concerns about what's going to happen with unorganized workers, but I don't want to say that to suggest that employers, that it's going to be easier. We've had a lot of contact from non-unionized workers that already know that they want to complain. Some of them in management, some of them non-management, just excluded, or in workplaces that are non-unionized. It's going to be hard, from what I've seen, for them to litigate gender neutrality of a job evaluation system, because, as Paul said, I think Paul mentioned this, it's taking a long time. We're using a lot of experts. It's very expensive, and I don't know what the answer to that is. However, they have a right to go to the tribunal. If they go and they, I think we may see someone going in there and said, "I was asked to fill out this questionnaire. This does not reflect my job." And the tribunal is going to make a determination on that. So and I don't think they're going to, they're not going to want to penalize an employee because she's not in a union, and can't afford a lawyer, and so on. The other thing is, to get back to review services, although it appears to me from reading the Act, they're supposed to investigate and decide as well as conciliate and mediate and so on. They're not doing a lot of investigation in terms of the gender neutrality of job evaluation systems. They're asking the parties to negotiate that, and if they agree, they're supposed to look after their own interests, and that may be appropriate, but I don't know. It doesn't seem to me that that's going to be appropriate when it's a non-bargaining unit situation. So I don't know what they're going to do in that case. In fact, they may start looking into the gender neutrality of job evaluation systems on their own when there's no union involved. And just to touch on two things that were mentioned by Paul and Nan. Actually, I'll just comment on something mentioned by Paul. The Act is not actually completely silent on the allocation of of payment adjustments. It says under Section 13 sub 3 that female job classes with the lowest job rate should get the increase first, up until the time that this is my understanding of it, up until the time that they're equal with the next lowest female job class, or the act is achieved, or pay equity is achieved. There's a lot of little things like that in there that get missed. And with respect to Nan's comment on the appropriateness of factors depending on whether it's sort of a male-dominated industry or female-dominated industry, I don't know. I mean, I wouldn't necessarily accept that. I have to think about it just before I would agree with that, certainly in counseling a client. Well, I think that's all I need to comment on. Do you think?
I think in light of the time constraints, that I would like to thank Laura and Paul and Nan for their very interesting views on gender neutrality. Stay tuned. I think it's fair to say that the cases will continue to be litigated for some time, and that it will be some months before the first decision is rendered as to what's gender neutrality, what is gender neutral. But thank you very much. Paul mentioned that some of his clients might not actually complete the pay equity process on time. As unlikely as that really could possibly be, the next segment of the program looks at the portion of the aspect of remedies under this act. Nancy Cathy, who is a lawyer at the law firm of now Faskin, Campbell and Godfrey, will present a paper that she has co-authored with George Adams with respect to remedies under the Pay Equity Act. Nancy is a graduate of the University of Western Ontario and has been practicing management labor law since her call to the bar. Her paper, which is in the materials, then looks at the remedial power found in the Act and the extensions thereto. Elizabeth Lennon, who is a partner in the law firm of Cavalluzzo, Hayes and Lennon, is going to appear twice today. And this segment, she's going to present the paper prepared by Paul Cavalluzzo with respect to the role of review services in the remedial portion of the Act. Elizabeth Lennon is a graduate of Dalhousie Law School, and she has her master's in law from Harvard University. She practices labor law representing unions and employees, and has specialized in the area of equality law. Nancy, you've agreed to go first?
Mm-hmm. Thank you, Beth. When discussing remedies under Ontario's new pay equity legislation, I think that it's essential to bear in mind that the administration or day-to-day application of the remedial provisions of the Pay Equity Act will be determinative of two very important things. First, the strength of the rights that are conferred pursuant to the provisions of the Act, and second, the viability of the Pay Equity Commission to which the remedial powers have been delegated. I would suggest that should the Commission not exercise its remedial authority in a fair and even-handed manner with certainty and predictability, with a view to being both fully compensatory and sensitive as well to the principles of general deterrence, then the rights that have in effect been granted under the Act will be rendered to a certain extent illusory. What this means is that there's going to be a need for an ongoing balancing of the delicate interests that are protected by this act. And I would suggest that if the commission employs its remedies with too zealous and single-minded an effort, it's going to undermine the integrity of the pay equity experiment. And conversely, if it utilizes too meek and mechanistic an approach to its remedial authority, then working women will be demoralized, and this will have a consequent adverse effect on the integrity and the credibility of the officials who are charged with enforcing the statute's provisions. Now, examining the remedial action sections of the Act, we see that the Act purports to enforce those rights which it confers on employees, employers, and bargaining agents by means of a complaint mechanism. Pursuant to subsection 22(1) of the Act, any employer, employee, or bargaining agent may file a complaint with the Commission alleging a contravention of the Act, the regulations, or an order of the Commission. In addition, subsection 22(2) confers upon employees and bargaining agents the right to file a complaint with the Commission complaining that a pay equity plan that applies to an employer is not being implemented according to its terms, or that because of changed circumstances in the establishment in question, the pay equity plan is no longer appropriate for the female job class to which the employees belong. Now, presumably, when the Commission receives a complaint, a review officer will be appointed pursuant to subsection 23(1) of the Act to investigate the complaint and to endeavor to effect a settlement. Unfortunately, once a review officer has been appointed to examine the substance of a complaint, the remedial powers of the officer, both adjudicative and mediative, are effectively activated, and it's this dual function in the review officer that I would suggest is bound to impede his or her settlement effectiveness. It's curious to note that the Review Services branch of the Pay Equity Commission maintains that the remedial process that's contemplated by the Act may be triggered in certain situations where a formal complaint has not been filed. And the branch maintains that a review officer, in the absence of a formal written complaint, may exercise his remedial powers if he is of the opinion that a pay equity plan is not being prepared as required by Part 2 of the Act, a pay equity plan is not being implemented according to its terms, an employer has breached its statutory obligation to establish and maintain compensation practices that provide for pay equity, or an employer or a bargaining agent has violated its duty to refrain from bargaining on or agreeing to compensation practices that, if adopted, would not provide for pay equity. Now, relying on the inclusion in subsections 24(1), 2, and 3 of the phrase, quote, where a review officer is of the opinion, end of quote, as a prerequisite to the exercise of the review officer's remedial authority, the branch suggests that if in these fact situations the legislature had intended the review officer only to act upon the receipt of a formal written complaint, the legislature would have included in Section 24 a reference to the review officer having investigated a complaint, in addition to the mention that's made of the review officer having formed an opinion that one of the enumerated fact situations is indeed in existence. So presumably the Commission is prepared to a certain extent, bypass its own complaint-triggered remedial process in favor of informal, request-activated remedial process in certain limited situations. Now, further evidence of this sentiment can be drawn from the branch's view of the remedial authority conferred by subsection 16(2) of the Act. By way of background, 16(1) provides in part that if the Commission is advised by an employer or a bargaining agent that no agreement has been reached on a pay equity plan, a review officer will investigate the matter and will endeavor to effect a settlement. Subsection 16.2 stipulates that should the review officer be unable to effect a settlement, he or she shall by order decide all outstanding matters. Now, without touching on the potential scope of the remedy conferred by 16.2, it becomes obvious that a reference to a formal complaint having been laid is again absent. So, once again, the branch maintains that a formal complaint is not required to trigger the exercise of the review officer's remedial powers, and once again, the branch maintains that if the legislature had wanted to limit this exercise of remedial powers to situations involving a formal complaint only, it would have so explicitly provided. Now, be this as it may, one of the key problems in the entire review officer procedure is the fact that the review officer is given the remedial authority to decide all outstanding matters, as well as being given a settlement role. Now, the former power, I would suggest, may very well serve as a deterrent to candid settlement discussions between the parties, because surely the prospect that the officer may by order decide contentious matters after he's already taken into consideration statements made or admissions tendered by one or both parties in the heat of the settlement negotiations, then I would think that this may cause parties to want to censor or stifle the information that they reveal during the entire mediated settlement process. So one serious concern is whether the settlement procedure as set out in Section 16 of the Act will be able to generate any substantial degree of effective settlement efforts. And unfortunately, this is something that the officials can't really change in any way because it's specifically set out in the legislation. Now, touching on the orders of review officers, as I've mentioned, it's Section 16 and 24 that are the two provisions in the Act that delineate the scope of the orders that the review officers can make. As I noted, 16.2 confers upon an officer the authority to settle by order all outstanding matters in situations where the parties have been unable to reach an agreement on a pay equity plan and the officer's unable to effect a settlement. Now, it's important to note that 16.2 really creates a mandatory obligation, unlike Section 24, which suggests that the officer may issue an order. Subsection 16.2 obliges the officer to order the effective resolution of outstanding pay equity bargaining issues. Now, in addition, Review Services Branch is of the view that 16.2 must be interpreted as granting very broad remedial powers. The branch maintains that should the parties negotiating a pay equity plan fail to arrive at an agreement on a plan, subsection 16.2 mandates the review officer investigating the stalemate to decide by order the contents of the entire plan. Now, presumably the officer's order is going to be limited to a handful of issues upon which the parties have failed to agree. But if you go with the branch's view, the scope of the provision is really such that that a review officer could clearly decide the entire contents of a plan should the parties' failure to agree be that broad that they have failed to agree on an entire ambit of pay equity issues or a pay equity plan. It's interesting to note the potential ramifications of the broad remedial authority that is granted by subsection 16.2. A review officer, once again, is given the authority to decide all outstanding matters, and which relate to the creation of a pay equity plan. So, in effect, the officer is given the authority to decide human resources and compensation aspects of a employer's business that's really akin to the role of an interest arbitrator, which up until this point in time anyway has really been confined to the public sector. And moreover, this particular arbitrator has a right to seize, record, and investigate on his own inquisitional initiative. So while while that statement may seem to sort of overstate the breadth of the review officer's authority, I think if you look at it closely and look at the provisions of the Act, you'll appreciate that it really doesn't, because this would seem to be the nature of pay equity. And I would suggest that some effort will be necessary, therefore, to ensure that due process in this whole process is seen to be done. Now, as as Mr. Adams and I have discussed on pages 9 and 10 of our paper, subsections 24(1), 2, 3, and 4 of the Act dictate the nature of the orders that may be made by a review officer in certain specified situations, and particularly situations where a pay equity plan is not being prepared as required under Part 2, where a plan is not being implemented according to its terms, or where a review officer is of the opinion that there's been a contravention of subsections 7.1 or 7.2. I think attention should also be paid to the broad array of powers which are given to a review officer in the exercise, or to aid him in the exercise of his remedial authority. And I refer you to page 11 of our materials, where we have set out subsection 34(3) of the Act, and that section enumerates the powers which have been granted to review officers, and which include a right of entry, a right to request production of documents for inspection, a right to seize these documents for purposes of taking extracts or making copies, a right to question, and a right to provide that any particular job class is a female job class within the context of an order made under section 24(1) or subsection 16(2) of the Act. Now, giving further delineation to the nature of the powers that have been conferred upon review officers, subsection 34(4) of the Act provides that the Statutory Powers Procedure Act does not apply to the review officer, and he's not required to hold a hearing before making any order authorized by the Act. Now, at first blush, this would seem to legislate unnatural justice, but Review Services Branch maintains that the officer's ability to decide matters without the trappings of the SPPA is really kept in check by the reality that an employer or a bargaining agent that is named in an order of a review officer has the right, as conferred by subsection 24(6) of the Act, to request a hearing before the hearings tribunal with respect to that order. Now, the availability of the request for hearing, I would suggest, may not be sufficient to overcome any adverse perceptions that the parties may have as a result of the inquisitional review procedures. And once again, there's a stumbling block in the mediated settlement process, as I discussed earlier, with the review officer being given the authority to both decide outstanding issues and to play a mediative role. Clearly, the administrators of the Act are going to want to watch the experiences of the review officers carefully to determine whether the incidence of the orders is too high or whether their entire process is too conflict-ridden. Now, touching briefly on retroactivity and interest, subsection 16(6) of the Act provides that where adjustments in compensation are made after the date provided in the Act, then the employer will make these wage adjustments retroactive to that date. Review Services, once again, is of the view that the natural extension of this provision in the Act is that the review officer would have the authority to order that interest be paid. Now, whether in fact that interpretation is correct and whether that's so easily drawn from 16(6), I won't comment on, but be that as it may, I would suggest that there's also a possibility that an argument could be made for the apportioning of costs between an employer and a union in situations where retroactive payments are ordered and more importantly, where interest is ordered. I think the theory or the rationale for such an argument would clearly be that, particularly in situations where you have a delayed payment being made or a delayed adjustment being made by reason of stalled negotiations, and stalled negotiations being in effect a result of the hard bargaining of both sides, union and employer, then it would just seem a common sense argument anyway to suggest that as both parties had a hand in stalling the negotiation process, then both should bear the cost of the interest that is awarded with respect to retroactive wage adjustments. Yes. With respect to orders of the hearing tribunal, you'll see that summarized on pages 15 to 17 of materials. The only other thing I'd like to comment on is fines and offenses. Under 26(1) of the Act, anyone who hinders a review officer, intimidates anyone under the Act, or who fails to comply with an order of the hearings tribunal may be charged with an offense, liable upon conviction to a fine of $2,000 in the case of an individual, or $25,000 in any other case. And this, of course, is contingent upon the written consent of the tribunal being received before a prosecution can be initiated. So you can see that there's an impressive array of remedial powers that have been drafted to enable the Commission and its review officers and its hearings tribunal to protect the rights that have been granted under the Act. You can also see that Review Services has given a lot of thought to how it will administer these remedies on a day-to-day basis. The only question I have is, whether we shouldn't be a bit concerned that there's sort of now predetermined responses to questionable areas in the Act without any involvement of the parties. But nevertheless, I don't think anyone can accuse the Commission of having taken the legislation lightly, or no one could argue that the prime beneficiaries of the legislation are not getting anything less than a first-class effort.
I have a particular interest in making sure that we get through this part of the proceedings expeditiously, since I'm also on the next panel. I don't intend to present the paper that's in the materials, but I do strongly urge that you read that together with the paper written by Nancy and George. On my quick reading of Nancy and George's paper, it gives you quite a detailed analysis of the statutory language around the role of review officers, as well as around the role of the hearings tribunal. The paper produced by our firm, Paul Cavalluzzo and Karen Schuker, deals in some detail with the jurisprudence to date on the relationship between the hearings tribunal and the review officers, and I think that will be interesting and helpful for you as well. So I'd strongly suggest that you read those. Also in the materials, if you don't have much sense of what a review officer's order looks like, there's one attached at page G17 to the paper on the information problem, which the paper itself is really more relevant to the next session, but the order made by the review officer in the cybernetics case is attached to that. I do, although I'm not going to deliver the paper, do want to make some comments about the reality of what's happening in review services now, and the reality of what will probably be happening there after January 1st, 1990. The statistic that 80% of matters in review services now are being settled, I think is probably somewhat misleading. When you think about what issues are before review services now, the first mandatory posting date is fast coming upon us, but it's not upon us yet. And review services officers, to my knowledge, are not yet settling plans. They're dealing with complaints that there have been violations of the Act of various kinds, and they're dealing with a number of substantial and important issues that are arising in the course of negotiations, but they're dealing with them on a somewhat piecemeal basis, because that's the way the parties are presenting them to review services at this point. There are lots of problems that the parties need assistance with, but they don't, at least at this stage, want review officers to step in and settle their plans for them. They want to retain negotiations in their own hands, to retain control over their plans as long as that's possible. So they're asking for assistance on preliminary types of issues, intermediate types of issues, but not asking to have plans settled for them. So there isn't a lot of precedent, even in review services, for what will happen when a review officer actually settles a plan. With respect to complaints, Laura noted that review officers have not yet made findings with respect to bargaining in bad faith. I think it's fairly arguable under the statute that they don't have any jurisdiction to make orders with respect to bargaining in bad faith. They certainly have jurisdiction to make orders with respect to complaints about particular other violations of the Act, particularly violations of Section 7. But although this isn't an issue that's been before the tribunal yet, I think it's quite possible that they have no jurisdiction to deal with bargaining in bad faith. And in fact, for all the reasons that have been outlined before you about their procedures, they're not really very well equipped to make findings of bargaining in bad faith, which seem to lend themselves more to a full-fledged adjudicative process. So there's certainly settling things on agreement of the parties, dealing with piecemeal, if I might call it that, negotiating issues, and some complaints. But in my experience, and one of the things I've realized listening to some of the other speakers is that at this stage it's very dangerous to generalize from one's experience. But from my experience, if issues go to review services, which are really a fundamental and important part of somebody's negotiating game plan, whether it be the unions or the employers, they're not going to be satisfied with the order that's made in review services. And those issues are going to go virtually automatically to the tribunal. And for those kinds of issues, the review services process is really simply regarded as something of a roadblock on the way to the main event, which is the hearing before the tribunal. And of course, the structure of the statute encourages that attitude to review officers' orders with an automatic right to a hearing de novo in every case. It's also, to some extent, I think, been encouraged by the jurisprudence of the tribunal on the relationship between review orders and their hearings. They have clearly stated that they take the view that this is a hearing de novo and that no party gets any kind of